Hello and welcome to Family Law Hour, the monthly series where you can get all the information about the family law process in Colorado. Welcome. Can you believe it's March already? Somehow this year is going super slow and super fast all at the same time. So this month, I'm really excited because the topic we're going to cover is all about the financial disclosures that are required in the family law process. Now, this isn't necessarily a fun topic. I don't know if any topic in the divorce process is fun, but this is one where I definitely get a lot of questions. So I'm really excited to share that information with you today. If you're like me, you've maybe found that getting information online can sometimes be really helpful and you can learn a lot. And sometimes you're not quite sure if what you're reading is either truthful or accurate. And the court process is no different, right? The legal process in Colorado is complex. It's something that you don't experience every day. They use really funny words that nobody else uses on a daily basis. And so when you're entering into it or are in the middle of it, it can be really overwhelming just to find basic information about what you need. And when you go to the internet or you Google it, that's a great resource, but sometimes you may not be getting truthful information or just not accurate information because what you're reading hasn't been updated. So that's why I started this Family Law Hour webinar, was to provide the up-to-date information about the process here in Colorado. So my name is Lauren. I'm a family lawyer here in Colorado. I help folks break up for the better. And I just don't believe that people should have to deplete their savings or go into massive debt just to break up because of these massive legal fees. And believe me, I have seen folks pay $10,000, $20,000 or more just to break up. And if the parties are being amicable and getting along with one another, I think that should be rewarded. I don't think that our jobs as attorneys is to use the unfortunate situation that you may be going through of a breakup to put money in our pockets, right? We're here to help you navigate the system and solve the problems that are in front of you. So my approach, as I hope you will see, is pretty down to earth. I take a pretty reasonable approach through the process, and I really just try and simplify things so that the legal process isn't quite as overwhelming. And hopefully by doing that, it sucks a little bit less. So with that being said, before we jump in, a quick disclaimer, every case is going to be different. So while family law cases generally follow the same construct, every family and every person is going to be different, right? So they all deserve individual attention. So what you will get from me today is about the process, but it's only information, and it's only information for cases in Colorado. Every state handles divorce and custody cases differently. So if you're watching from another state, welcome. But this information is going to be only for Colorado. So you'll want to check for your specific state. Nothing that I say today should be taken as legal advice for your particular situation. If you have specific questions about, well, how does this apply to me? Or what about this weird thing in my family? You want to talk to an attorney and not take anything that you hear today as advice. It is strictly information. That being said, let's jump in and talk about the finances of a divorce and custody case. So this is all the money stuff that you're going to run into when you open up one of these cases here in Colorado. So before, just to make sure that we're all kind of on the same page, I want to go over a few quick terms that you will hear if you're in the middle or starting a case in the courts, because the terms they use are slightly different. And so you may hear me interchange them, and I want to make sure that everything's clear. So a divorce is sort of what we all call when a married couple is breaking up, right? In the courts, it's a dissolution of marriage. So you may hear that term. It's essentially a divorce, right? So there is a married couple that may or may not have kids that need to end that entity that is the marriage. A custody case is going to be between two unmarried parents who have a child together. We refer to that as custody. In Colorado, it's an allocation of parental responsibilities case. A big mouthful, basically just means custody. So if you're in the middle of a divorce process or a court process, or you're looking for forms online and you're seeing APR or allocation of parental responsibilities, and you're going, what the heck does that mean? It's a custody case. And all of these cases for family law in Colorado are going to take place in the domestic court, in the district court in the county where it's applicable. If you watch last month's live stream recording, we go through how to start these cases and where to actually file. So if you're wondering about that, go back and watch. But that kind of gives you the general nomenclature that we're going to be talking about today. So financial disclosures. These are required in every case, both a divorce or custody case, and in a divorce, whether or not you have kids. They are required. They are mandatory. There's no question. The statute is written that this information about the finances has to be provided, and it has to be provided even if the other party doesn't ask for it. It's an affirmative providing that the court is requiring by the parties. I will say it's a more challenging part of the case just because there's a lot involved. It's not difficult necessarily to understand, but there's a lot of documents and numbers and things that are included. So it's not one of the more fun parts of a divorce or custody case. Like I said in the beginning, I don't know if any part is necessarily fun, but it can be a little bit more challenging and feel a little bit more overwhelming. But hopefully we can break it down today so that it's at least doable and you know the road to get through it. So let's talk about a couple of the documents that you'll need. Some of these you'll file, some of these you won't, and we'll talk about the specifics of those. So the sworn financial statement is going to be the crux of your financial disclosures. This is a document that just gives a snapshot of where your finances are at. So it's going to talk about things like your income, employment, mandatory and voluntary deductions out of that income, your expenses per month, your debts, and your assets. So it gives just a complete picture of your financial situation. You'll also have, if you have certain types of assets like retirement plans, investments, separate property, kind of different assets that are not super common, like maybe a health savings plan or a business interest or frequent flyer miles. There's a big chart in the sworn financial statement. If you have any of those types of assets, you also will have a supporting schedule that goes along with your sworn financial statement. And that's just really a space saver because those assets aren't as common. They didn't include space on the sworn financial statement to fill out the details about them. Instead, they said, hey, if you have these things, put the value on the sworn financial statement and then fill out this additional form to give us the actual details about those assets. So if you don't have any of those assets, if you're checking off none for all of those sections in your sworn financial statement, you don't have to worry about the supporting schedule. But if you do have them, you'll want to make sure that you include that as well. Along with your sworn financial statement, you will file a certificate of compliance with the mandatory disclosures. And this is a document that you're letting the court know and the other party know that you have complied with this mandatory requirement. And in addition to filing the two documents that you need to file with the court, you also provided all the supporting documentation to the other party. The court doesn't want that supporting documentation, and we'll talk about what's included in that in a second, but they want to know that you met the requirement and you exchanged that information with the other party. So that certificate of compliance is you're just saying, yes, these are all the documents that I provided to the other party court. I met the requirement that I'm supposed to follow. So good news, all of those forms can be found on the court's website, which is www.courts.state.co.us. Many counties also have a self-help center. So if this is something that as you're in it, you have some additional questions, you can reach out to the self-help center in the county that your case is in. And just like I said in the beginning, try not to Google it. I know that it's super tempting and easy, but you just don't want to get misleading, false, inaccurate information that could be detrimental to you down the road. So really make sure that any resources that you are using are legitimate, they have the latest information, and that they're going to be able to help you. So let's talk a little bit more about the supporting documents, right? Why do we have to exchange all this stuff? So when you fill out your sworn financial statement, you list things like your income. You put information about I'm employed here, I work this many hours per week, this is what my pay is based on, this is how frequently I'm paid. And you include at the very first section in your sworn financial statement what your gross monthly income is, right? So that's income before taxes. Anything is taken out, just your gross pay. So if we just put that number down, great. Most people put down the number that's accurate. But every once in a while, some folks don't, or maybe they inadvertently miscalculate it. Any of the numbers that are included in the sworn financial statement, we want to provide documentation that supports those numbers to show both the court and the other party that what we're providing is accurate. So that's where those supporting documents come in. So let's go through and talk about what those documents are that are required. And again, this is not a thing you get to choose. This is something that the statute says each party has to disclose if you are in a divorce or custody case. So the first thing you have to provide is the sworn financial statement. That's super easy. You're already filling that out. That's also something that you're going to file with the court. Next, you need to provide the 3 most recent years of income tax returns to the other party. I know that sounds like a lot. They have to do the same exact thing, so it's not one-sided, but you do have to provide those income tax returns. If you have any personal financial statements, you'll also need to provide those for the last 3 years. So that's anything if you have statements of assets or liabilities, if you have credit or loan applications, those are going to be those personal financial statements. So if you've had any of those in the last 3 years, you need to provide those as well. If you own a business or have an interest in a business, you also need to provide the last 3 years of business financial statements. So that's going to be things like the profit and loss, year-to-date financial statements, anything that will show what the business has its worth based on, you'll have to provide for the last 3 years to the other party. If you don't own a business, if you don't have an interest in a business, you don't have to worry about that. It doesn't apply to you. If you have any real estate or real property, you have to provide the documentation to support that. So sometimes it's the title if the house is free and clear. Otherwise, it may be a mortgage statement if you don't have access to the title. If the mortgage company is holding that, then you can just provide the mortgage statement, the sale documentation to show what the purchase price was, anything like that, refinance documentation, anything related to real estate documents, or real estate needs to be provided. Okay, personal debt. So any documentation showing the debt that you currently owe. So most recent statement is going to be most applicable. So credit cards, student loans, you want to provide the most recent statement. So again, when you write down on your sworn financial statement that I owe Capital One $1,000, the person can then look at that statement and go, yep, it says latest statement, Capital One, $1,000. And similarly, for any kind of investments that you have, investment accounts, you want to provide the most recent statement, again, verifying the value of what that investment is worth. If you have any benefits being an employee, so like health insurance, maybe you do HSA account, you get life insurance through your employer, anything like that, any type of benefit that you have from an employer that has that monetary value associated with it, you'll want to provide the documentation showing that. For most folks, this is probably going to be health insurance, where it shows the total amount that's deducted from your pay each week or every month or however you're paid, to show what the cost of health insurance is to you, and then obviously who's included on that plan. If you have any retirement accounts similar to investment accounts, so maybe this is a 401k through your employer or an IRA that you have personally, you'll want to provide the last statement for that account, again, to verify what the value is. Okay, all right, is this a lot already? I know these are a lot of documents, right? So like I said, it's not necessarily hard, but it is a lot to kind of get through and gather up. So definitely take your time as you're going through this. We'll talk about in a little bit what the timeline is for the court. Certainly something you want to start on sooner than later and work through it slowly, but it is something you can do and will be a good accomplishment and a good milestone completed when you finish it. So let's go through the last few supporting documents that are needed. The first is going to be bank or financial accounts. So checking account, savings account, account for maybe your child, like a minor's account that you hold, anything like that that you have, you want to provide the most recent statement that shows, again, the account balance and the information about the account. Income documentation. So wherever your income comes from, for most of us, it's from our employer. But if you have rental income, if you get dividends, if you get any state benefits, any kind of income that comes to you, you need to provide documentation of that income. So if it's just you're employed and you get a pay stub, you can provide your pay stubs. Generally, we like to say at least 3 months of your pay stubs just to kind of show a consistency. If anyone gets something like commission or their pay fluctuates, it allows then to give a little bit more of a history so that an average can be seen. Additionally, if you get rental income or government benefits, you'll have to provide information to show that income as well. If you are self-employed, that is obviously a little bit trickier. Sometimes we don't have pay stubs to show. And so for that, you'll need to provide anything you have to show income. Sometimes it just comes from the bank accounts, which we talked about earlier, the bank statements for businesses that shows the income going in to be able to pay the self-employed person. And again, as far back as you can go, at least 3 months. If you're providing your tax returns and you're self-employed, that's at least 3 years. So a good chunk of time can be seen for that income documentation. If you have any employment or education-related childcare costs, you need to provide the documentation to show those costs. So if kiddos in childcare, you pay a facility, you pay a private person, they're in aftercare, whatever it is, you need some documentation to support the amount that's paid each month. Insurance documentation, we talked about a little bit with the employee benefits. If you're not getting your insurance through your employer, you get it separately. You still need to provide the the insurance documentation for life, health, property insurance, dental insurance, vision insurance, any kind of insurance documentation. Not only should it show the cost per month, but also what's covered under that particular plan. If there are any extraordinary children's expenses, you have to provide documentation for that. Generally, this is going to be anything over $250 a year that's kind of consistently paid. This is not one that most folks have, but if you do have it, you have these extraordinary expenses for your children, you'll want to provide documentation to show what those amounts are. So that's all of the supporting documentation. Hopefully for most folks that covers everything. If there's anything that you will have listed on your sworn financial statement that we didn't cover, you still have to provide the supporting documentation for that to again show that the value you're indicating on the sworn financial statement is what the value actually is, or is what the debt is that is actually owed. As I mentioned, these are mandatory disclosures. The rules in Colorado are that the other party doesn't have to ask for them. It is a requirement that both parties just freely give the information over. This is both for a divorce and for a custody case. So why is that? For a divorce, whether the parties have children or not, the main function of the divorce is to not only end the entity, that is the marriage, but split the finances between the parties, right? We need to divvy up what the financials are, both assets and debts between the parties. And so we need to know what all those things are. So that's why these mandatory disclosures are required in a divorce, again, whether or not you have children. In a custody case, generally we're figuring out child support. And so we need all of that information to figure that out. Same thing if you have a divorce with children, you may need to figure out child support. And additionally, maybe maintenance or spousal support is going to be an issue in your divorce. So there's a lot of things around money and finances that we need to figure out, and we want to just make sure that everything is laid out on the table, nothing is being hidden. There is a strong consequence if you know of an asset or debt and don't disclose it. Again, these are mandatory disclosures. You are required to do them. You are required to be entirely truthful and put everything on the table. And if you don't, there are some strong consequences that happen if you don't do that. So don't make it harder on yourself. This process is already emotional. It's already difficult to go through. Just follow the rules as they are written. Okay, so once you have these documents, what do you do with all of them? The sworn financial statement and supporting schedule, again, if you have some of those assets that aren't specifically listed out on the sworn financial statement itself, and your certificate of compliance, a document that says, yep, I gave all of these supporting documents to the other party. Those are going to be filed with the court. So you give a copy to the other party and you also file them with the court. So you'll bring them to the clerk of court in the district court in the county where your case is. They will process them and file them into the case. Some counties now in Colorado, there's a slow rollout to allow electronic filing for everybody. And so if that's available in your county and you have signed up, you can also file them electronically. There is a cost associated with filing electronically, so be aware of that if you're going down that route. There shouldn't be a cost if you walk into the courthouse itself and provide the documents. What the court doesn't want is all of the supporting documents. So they don't want your pay stubs and bank statements and tax returns and insurance documentation and personal finance form. They don't want all of that filed with the court. They want you to provide all of that to the other party. And obviously you'll receive the same from the other party yourself. Don't file those things with the court, the supporting documentation, just the sworn financial statement, the supporting schedule if it's applicable, and your certificate of compliance. So when you send all of those along with your supporting documents, the big stack of everything, to the other party, you can either send it manually in the mail. You can just print everything out and send it, hand it to them, or you can send it electronically. So I know a lot of statements, bank statements online, health insurance probably, right? You just go online and can download the PDF of the statement. So if you have everything electronically, you can send it electronically as well. Just be sure that you redact any personal information, the full account numbers, routing numbers, social security numbers, even dates of birth, anything that's really sensitive, you want to redact. So you want to black out everything but the last 4 digits. So that's all that we need to actually identify that this is the correct account, but we don't need to have exposed. So especially if you are sending them electronically, you want to make sure that you black out that document so that someone can't see it who shouldn't be seeing it. All right, what is the timeline of all of this, right? Because it seems like a lot of work, and it is. So what does the court expect all of this to be done by? So generally, the rule of thumb is once service has been complete, within 42 days, you want to have all of your financial disclosures done and exchanged and filed the documents that you need to file with the court. Usually there's a status conference that's set up around that same time. Ideally, you would go into the status conference and say, I've got all this stuff done already, but sometimes that's not entirely feasible. So as long as you are working towards it, doing as much as you can, getting as much done as you can, as quickly as possible, that would be great. But if you can shoot for that 42 days after service as your deadline, that would be fantastic. And then you know that it's done and you can move on to the next thing. So all of this I know is a lot. Gathering all of these documents can be a lot. It can be overwhelming. I will reiterate, as I said last month, the process is designed that you can do it on your own, right? I told you where the court forms were. You can go online, you can download your own sworn financial statement, you can fill it out, you can file it. So the system is designed in Colorado that you can do it on your own. But if you are sitting here thinking, wow, that was a lot, or just this whole process is a lot, I totally understand. And that is one reason that we have this webinar going on. And that's also one reason that there is customizable services from attorneys that you can use to help kind of feel a little bit less overwhelmed and know what to do in the process and get all of those questions answered. So before I kind of get into how to get legal help, how to go through this process without spending a ton of money, how actually to get it done for less than $500, I just want to answer some 2 quick questions that we got in that are pretty common ones. I want to make sure that we cover them. So the first one is, what if the other party already has the document? So let's say you're married and you filed tax returns jointly for the last 3 years, right? So your tax return is exactly the same as your spouse's tax return. Do you have to provide the tax return to your spouse? The answer is yes. I know that it feels unnecessary, like an extra step maybe, that do we really need to do this? But the court is going to defer to everybody exchanges everything they need to exchange, even if what you're passing back and forth might be the same or exactly the same document, 2 copies of the same document. So even if you think that bank account she has access to, she's on the bank account too, why can't she just pull the statement? I hear you. I understand, but we're going to follow the court's process just to keep everything simple to avoid any unnecessary bumps in the process. So if you've got a joint bank account, print out the last 3 statements and send them along, and know that you should get those exact same 3 back. And that's actually a good thing, right? That means everybody's above the table. All of the numbers are adding up. There's nothing funky going on, nothing hidden, no numbers being changed, right? So it's just peace of mind, even though I understand it is a little bit extra work and it seems a little unnecessary. So do make sure that you provide all the documents that have your name on them, that you have access to the other party, even if they have access to them too. So next, someone asked, why are all of these documents necessary for a custody case, right? Great question. So in a custody case, they're unmarried parents, so we're not going through and allocating all of the assets and debts between them. So why do we have to provide all this documentation about, let's say, like retirement accounts or my insurance? Totally hear you. Great question. The court treats them in terms of this part of the process as similar. And so the rules are the same. The court requires that the same documents are exchanged, whether it's a couple going through a divorce, so they're married, or a couple who has broken up, or 2 co-parents who need a parenting plan in place. It's treated the same. So I hear you, especially if you're not married. Why do you have to provide all these documents? Because it's the rule. And again, we don't want to create any unnecessary bumps or challenges or times before the judge that we don't need. Just follow the rules and provide the documentation. The process is already hard enough. It's already emotional enough. Don't kind of add, to it just because you're frustrated or you think that it's an unnecessary step. I hear you. I totally understand, but it is what the court requires. And because we are figuring out child support for custody cases, we have a formula for that, which doesn't necessarily include considering what's in your retirement account, but sometimes those extra ancillary assets are considered if the court is looking at things a little bit differently. If they're considering a deviation or whether a party has the means to pay for something, they're going to look at some of those outside assets or debts, liabilities that the person has. And so we want to make sure that all the information is just accurate and has been provided up front. So great question. Sorry, I don't have a better answer, but following the court rules is always going to be the path of least resistance. So if you are feeling pretty good, you're getting the information you need, you can go through the process, you and the other party are amicable, you're talking, you guys want to figure this out and just get it done without adding any gasoline to the fire, that's fantastic. And the extra bonus for that is you can complete the process for less than $500. That is the secret to doing it. It's not magic. It's not knowing a certain person to talk to or doing it a certain way. If you go through the process step by step and you are willing to work with and compromise with the other party, you can complete either a divorce or custody case for less than $500. And most of that $500 fee is going to be fees that you'll incur anyway. Fees for filing, possibly for mediation, for service, right? You're going to have to do those whether you guys are best friends, which is not likely, but getting along really well or can't stand to be with each other. So limit as much as you can out of pocket by just having to pay those fees that are always going to be necessary, and avoid paying several $1,000s that might be unnecessary to attorneys because y'all can't get along. So a traditional lawyer, I saw recently, the average cost of a divorce is $15,000 per party to get divorced, to break up. I don't know about you, but that's not money that I necessarily have. And even if I did, I don't know if that's where I want to spend it. So avoid doing that by compromising, and then also finding an attorney if you do need some help, which is totally normal. This process is not something we do every day. It has uses words we don't use every day. It has some nuances to the process. If you need some help, you're not required to fit in the one-size-fits-all box and pay a traditional attorney who costs several $1,000s, right? If you're willing to do some work on your own and work with someone who offers some more customizable services, you can also get legal help without breaking the bank. Probably isn't going to be less than $500, but it's certainly, you can avoid paying $15,000, $20,000 to break up. So one of those options, if you are interested, is my online step-by-step guide throughout both divorce and custody cases from start to finish. You get all the information you need, all the forms you need, when you need them, the steps you need to take to finish your case on your own terms. That is a huge, it encompasses everything that you need, and it's only $25 a month. You get a 7-day free trial, so you can try it out and see if it will work for your case. But for $25 a month, you get all the information that you need to finish your case. Again, you might even be able to squeak that under that $500 line in the sand there and still have a bunch of information that you know is accurate, was written by a lawyer, reviewed by lawyers, so that you have everything you need to complete a divorce or custody case in Colorado. So you can check that out. You can sign up today. It's at colawguides.com. Again, that's colawguides.com. If you need a little bit extra help, you're not entirely comfortable doing it on your own, you want just to be able to ask an attorney some questions as you go along the process, I also offer a monthly coaching subscription that you can sign up for at any time, and you can cancel it at any time, use it as long as you need it. But you can have someone to be able to send all of your questions to get that guidance and information, so that as you're going through the process, you're not missing something. You feel like you've got that peace of mind that you've got everything covered and you understand what's going on and what's next. Additionally, from there, if you are like, I have watched this, I don't even want to deal with this financial piece, let alone the rest of the case, please just help me take over for me. I don't want to deal with this. I also offer more full service, full representation options. You can find all of my services and pricing. It is all flat fees, so you know the cost upfront and you can choose what works with your budget. You'll find that all on my website, mylifelawyer.com. Again, mylifelawyer.com. I hope that today was helpful. I know that we covered a lot. I know going over the finances is not fun, and it can be one of the more overwhelming parts of the process. But hopefully we were able to break it down in a way that made sense and that gave you the information you need so that you can complete the step of the process. Thank you so much for watching. If you are interested, I will be back next month and every month thereafter on the second Wednesday at 12 p.m. Mountain Time. We'll cover a new topic each month and work our way through the entire process, giving you all the information that you need so that you can feel confident going through it. Thank you so much for joining us today, and enjoy the rest of your day.